Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thanks for watching. A rare Sunday docket. First, Lori Vallow, nothing but misdemeanors. Second, George Floyd, no television. You'll be surprised who objected. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thanks for watching. We have a rare Sunday edition. Hope you all enjoyed your 4th of July holiday. As always, if you haven't already done so, we'd ask that you hit that subscribe button, hit that bell so that you receive notifications of when we go live or put up new content, and as always, leave us a comment below. Let's get to our rare Sunday docket. Lori Vallow. Well, Friday, we came out with a video that said that there were reports that the desertion charges against Lori Vallow were going to be dismissed. Nothing had shown up on the official court's webpage, but it did late yesterday. So we thought we would bring you that news as quickly as we could. And well, that just happens to be on Sunday. So on July 2nd, officially at roughly 1:58 p.m., the district attorney filed an amended criminal complaint in the criminal case of 33-20-0302. That's the complaint with Lori Vallow, also known as Lori Noreen Daybell. And in this amended criminal complaint, it no longer has the desertion charges. It simply has the obstruction of an officer, which is a misdemeanor and carries no more than 1 year in jail and a $1,000 fine. And it alleges that Ms. Vallow, on November 26 of 2019, did willfully delay and or obstruct the public officer, to wit, Lieutenant Ron Ball of the Rexburg Police Department, in the discharge of his office by giving false information regarding the whereabouts of a child, JV. Obviously, that's JJ Vallow. Additionally, count 2 is a misdemeanor count of solicitation that carries up to 6 months in jail and a $500 fine. And basically, that was the call alleged to have been made by Ms. Vallow to Melanie Gibb, which encouraged and or requested her to engage in conduct which would constitute the crime of resisting and or obstruction of a police officer regarding the whereabouts of the juvenile JV, obviously JJ Vallow. Count 3 alleges, once again, a misdemeanor of contempt, which basically alleges that by refusing or failing to physically produce a minor child, JV and TR, JJ and Tylee, to the Rexburg Police Department and the Idaho Department of Health and Welfare. Once again, a misdemeanor, up to 6 months in jail. The felonies carrying up to 14 years in prison have been dismissed. Now, Ms. Vallow still has case number CR 22-20838, which is the conspiracy to commit destruction, alteration, or concealment of evidence. And those two felony counts carry up to 5 years in prison. Now, I understand I am a criminal defense attorney. If I was a defense attorney for Ms. Vallow, I'd say, they couldn't have proven it anyway. However, I think in this particular case, the district attorney is wrong. Basically, what the district attorney is saying is, well, we produced the children, therefore she couldn't have or was unable to do so, and therefore we're going to dismiss those charges against Ms. Vallow. Think about it in this regard, ladies and gentlemen. Let's use this as an example. Let's say that I were to steal your car, which means I took it without permission. I drove it around for quite a while. You didn't know where it was. You thought maybe I could have had it, but that I didn't produce it in any way, and that ultimately I was the one who took your car. If ultimately I produce the vehicle and say, oh, look, here's your car. Yeah, I took it without your permission, and therefore no harm, no foul, everything's cool. No, the law doesn't recognize it that way. Me returning the car would simply be mitigation, something that could possibly reduce the penalty of the offense. But I took the car without your permission. That's the theft. It doesn't end just because I return it. What if I say, not only did I return your car that I took without your permission, but I gassed it up and washed it as well? Does that mean that I would get to be paid for my extra services or somehow takes away the crime? No. Abandonment takes place at a particular time, as alleged in the original complaint, which is when they failed to provide for the health and welfare of those children. It doesn't somehow stop at a particular date because they were deceased. I think the district attorney made a mistake here, and that's coming from even a defense attorney. So even on a rare Sunday docket, let's take a quick recess. And as you know, we have had a sponsor here for the last several weeks. And let me tell you, I want to read a comment that I had in our comment section. It said, "Thanks to Scott's background search, I just found out one of the guys that was interested in me had sexual abuse of a minor charges and that he lied about it. I feel so disgusted for talking to him, let alone cuddling with him." Ladies and gentlemen, this is an example of why everyone should have a subscription for a background search. Bottom line, information is power, and that power lets you make the right decisions because you have the information. So if you sign up for a subscription at CrimeTalkSearch.com, yes, you can anonymously run the background search of anyone here in the United States. You can search billions of public records, and then you receive a report that's generated while you wait, which includes social media information, emails, phone numbers, criminal history records, which includes sex offender registration, property records, bankruptcies, all the type of information that you want to know about the people you are dealing with, and perhaps even the ones that you are going to be involved with in an intimate relationship. You cannot go forward without a background subscription. Go to CrimeTalkSearch.com and sign up today. You'll be glad you did. You won't be disappointed. Next on the docket, the George Floyd matter. Last week, we brought you a story about the defense has requested that all of the proceedings for the officers charged in the death related to George Floyd be televised so that media could be in there for all the proceedings. And under the rules there in Minnesota, all parties need to agree, and the court ultimately has the final say-so. In this particular case, late last week, the court issued an order. The court said in its order, I'm basically not going to allow it. And the reason I'm not going to allow it is because, while it could result in an unfair trial, I'm not really sure how the truth coming out and being presented uncensored would be prejudicial to a jury trial. But additionally, the little tidbit that I thought was rather interesting was the state. The prosecutors did not want any of the proceedings televised. Remember, ladies and gentlemen, it's the state who has the burden of proof. They do. The only reason stated by the prosecution was that they objected and they think that it would result in an unfair trial. I'm not sure who they think it would result in an unfair trial for. In this particular situation, the defense is saying, televise it. The state is saying, no, it'll be unfair. To the state, let's wait and see. Obviously, there'll be reporters in there, but we won't get to see it exactly as it happens. That's all we have for a rare Sunday edition for Crime Talk. Thanks for watching. We'll see you next week.